In a new and very consequential ruling, the U.S. Supreme Court just voted to allow a Republican member of Congress to challenge legally a state election law.
Now, lawmakers are back on Capitol Hill to start Utah's 45-day legislative session. It's the start of what our team likes to call drinking from a fire hose, where hundreds of changes to state law will be proposed.
A state redistricting case in front of the Supreme Court that could end up having major ripple effects for the Voting Rights Act.
Hello, everyone. Today I'm going to explain a very important decision from the U.S. Supreme Court that has a big impact on how election rules can be challenged before voting even happens. A few days ago, on January 14, 2026, the Supreme Court made a major ruling in a case called Bost v. Illinois State Board of Elections. In this case, the court said people running for federal office, like Congress, can go to federal court to challenge state election rules even before election day starts. They don't have to wait until after the election ends. What was the rule about? It began with a congressman from Illinois named Mike Bost. He and other candidates wanted to challenge a state law in Illinois that allows election officials to count mail-in ballots that arrive up to 2 weeks after Election Day, as long as those ballots were postmarked on or before Election Day. Bost believed this rule shouldn't be allowed and wanted to sue to stop it. Before this decision, lower courts said Bost didn't have the right or standing to sue because he didn't prove that the rule would hurt his chances of winning. But the Supreme Court said yes, he does have the right to sue simply because he's a candidate for office and the law affects how votes are counted in his election. So what does that really mean? The Supreme Court didn't rule on whether the mail-in ballot law is good or bad. They only decided that Mr. Bost and other candidates are allowed to bring the case to federal court. The court said candidates have a special interest in the rules that decide how elections are conducted because those rules affect the integrity, the fairness of the election itself. The final vote was 7-2, which means 7 justices agreed with this idea, but 2 disagreed. The 2 justices who disagreed argued that just being a candidate shouldn't automatically give you the right to sue. You should have to show real harm first, like most people have to do in federal court. The court's majority opinion said that a candidate's interest in fair elections is different from the interest of regular citizens, and that's enough to allow them to go to federal court. That's why this decision matters so much. Now, this decision doesn't fix the mail-in ballot law yet. It only gives the candidates a chance to argue about it in court. But because it opens the door for candidates to challenge many kinds of election laws before voting starts, it could inspire a lot more legal fights in the future. Some people think this could help protect election fairness, while others worry it might cause confusion and more disputes around election time. You might be wondering why this matters to people who aren't running for office. The reason is that election rules, like how mail-in ballots are counted, when votes are counted, or how districts are drawn, can affect everyone who votes. Some legal experts think this ruling will mean more pre-election lawsuits, because candidates no longer have to wait to show actual harm. This could lead to judges deciding important election rule questions before voters cast ballots. Other experts worry that this could create a flood of lawsuits and make election seasons more chaotic. It's also interesting that this decision didn't split the court exactly on political lines. One justice in the majority wrote a separate opinion, and the 2 dissenters came from the more liberal side of the court. That shows the issue isn't just about politics, but also about how we think federal courts should work. This case is just one of several major election-related issues the Supreme Court is looking at right now. There are other challenges about redistricting maps and voting rules in places like California that could also go to the Supreme Court and affect how elections work in 2026. To summarize in simple terms, the Supreme Court has decided that candidates can go to federal court before an election to challenge election rules, even if they haven't shown that those rules will hurt them personally. That could change the way election laws are dealt with in courts across the country. If you're interested in elections, voting rights, or U.S. law, this is a story worth following. because the next steps could shape how Americans vote in the years ahead. Thank you for watching. Make sure to subscribe and leave a comment about what topic you want me to cover next.